Hello everyone, Attorney Nydia Menendez here with the question I really want you to think about. What is the difference between a will and a trust? Once you understand the difference between these two estate planning tools, you will be in a much better position to decide how to best protect what really matters to you. In a prior video, I explained that we all have an estate, and when we pass away, all that is left is our estate, at which time the only thing left in the estate is our stuff, our assets. We've also talked about the fact that a will is a document that activates at death, which you can use to leave specific instructions regarding the distribution of your assets. A trust, on the other hand, is a document that creates a separate entity. You can think of a trust as if it's a company. The trustee would be the president or the manager of the company, and the successor trustee would be like the vice president of the company. In other words, a trust has the ability to receive, keep, and manage your assets, and at the same time, a trust survives the person who created the trust in the first place, the settlor. What that means is that the trust can be managed by the successor trustee who was originally appointed by the settlor when the trust was created. Thus, an inherent benefit of a trust is that it is the settlor who nominates the successor trustee, and because the assets are already in the trust, there is no need for court involvement. The settlor is always in control. Yes, with a trust, if you become incapacitated, there would be no guardianship or living probate because you've already nominated the person or persons who are authorized to manage your assets, that is, the successor trustee, and it would be for your benefit. Or, when you pass away, there would be no need for death probate because your assets are already in your trust and you've nominated the successor trustees, and you've left instructions about what should happen with your assets. Not just who should get your assets, but also how your beneficiaries should get them. And this is a huge difference between a will and a trust. As I mentioned previously, in a will you can leave instructions about who will inherit your assets, but you cannot say how. For example, let's assume you have 3 children or 3 people you want to leave your assets to. One is super responsible but is contemplating divorce. The other one is the picture of irresponsibility and recklessness. With this person, money is like salt in water. It vanishes. And the third person has special needs and will likely never be self-sufficient. If you use a will to leave something for these individuals, that inheritance could be lost to divorce, lawsuits, creditors, or stupidity, or you could cause the special needs individual to lose government benefits that they would otherwise be entitled to. Hence, using a will to distribute assets to those you love and want to bless could do more harm than good. But if you use a trust for those gifts, in subtrusts for the benefit of each beneficiary could be set up to address their very unique needs. These are just a few examples which clearly show that a will is usually not the optimal estate planning tool. A trust is likely a much better alternative. Visit our website to register for a webinar where you can learn more about estate planning. If you like this video, please like and share. If you want to see more videos about estate planning, subscribe and ring the bell to be notified when we release the next video. Thank you for watching and see you soon.